In actual fact, although the advice is caution, the cases do give landlords quite a lot of leeway in relation to accessing the premises. Going back to some old cases, Bessel and Landsberg in 1845, the landlord there was held not to have accepted a surrender simply by carrying out necessary repairs at the property. Another old one, Ostler and Henderson, in 1877, the landlord there was held not to have accepted a surrender, even though it had attempted to re-let the property. And coming a bit more up to date, RVB Investments and Bibby in 2013, that was a situation where the landlord cleared the site, removed the tenant's waste, fitted padlocks, marketed the units for reletting, taken all of that together. That was still not considered to be sufficiently unequivocal to amount to a taking of possession by the landlord. Of course, actually granting a new lease to a third party, well, then that clearly would have been. If the supply of electricity, we'll call it electricity, and I say maybe it's just enough to keep the burglar alarm going. If it's a minimal amount, well, why does the landlord care? The reason being that if the meter isn't read immediately before this deemed supply contract comes into place, the utility company can raise estimated demands based on previous usage. Now, if the former occupier was, let's say, an industrial occupier with an enhanced supply and a high level of usage, then estimated demands could be very high. And in practice, on here's anecdotes that the first the landlord knows about a deemed supply contract having come into place is a very large bill lands with a resounding thud on their desk. Now, if all of that causes a problem and the tenant takes legal action of whatever sort, the likely outcome is going to be that a set of restrictions will be placed upon how the work is done. And the only way to head that off is to negotiate restrictions at the outset, so you forestall any action. And the inevitable result is it slows things down and it costs money. Now, during the pandemic, where we've had lockdown periods, that's often proved to be an opportunity for landlords to carry out work which they've had planned for a while maybe, but which was pretty difficult to accommodate with sitting tenants. So that's been a bit of a lesson, and it may well be that periods of vacancy, where a property falls vacant, will have that advantage, and it'll balance out some of these other things that we've been talking about.